All right, good afternoon, everyone. Today is Wednesday, March 2nd, 2022. We have 8 bills on the docket. We'll start off with Senator Hayes, who is not here, but we'll take his bill.
Staff is because he's on.
Okay, excellent. So with Senate Bill 758, we'll then move to 759, 815, 816, 775, 853, 746, and then we'll round out with 897. So with that, we will go on with Senator Hayes. Welcome with Senate Bill 758.
Thank you. As you guys can all see, I'm not Senator Hayes. So Senator Hayes is currently on paternity leave, as you guys know. So I would just be presenting the bill on his behalf. For the record, I'm Danielle Ziegler, Senator Hayes' Chief of Staff. So the purpose of Senate Bill 758 is to improve the public's confidence and provide transparency in the judicial system. So this bill will allow the general public to witness the system and work in real time through video streaming. Senate Bill 758 seeks to increase accountability of the judicial system by mandating public live video streaming of all public proceedings for cases of violent crimes. The bill stipulates reasonable exceptions to the video recording for jurors and alleged victims of sexual assault. Also, the court already has the technology in place to hold remote hearings and offer audio streaming. Therefore, transition to video streaming will not require an extraordinary effort. Senate Bill 758 will improve the public's confidence in our judicial system. It will allow for our residents to evaluate the judicial system's decision more accurately and clear up some of their suspicion. Overall, the bill provides a viable opportunity to increase the checks and balances across our judicial system in the 3 branches. For those reasons, I urge a favorable report on Senate Bill 758. And then following my testimony, I have Rebecca Snyder, who's the Executive Director of MDDC Press.
Excellent, thank you very much. I see Rebecca there. There you are. Ms. Snyder, come on up.
Good afternoon, committee, and special thanks to Senator Carter, my senator, for being a co-sponsor of this bill, so representing District 41. But I digress. So you've heard a fair number of bills this session regarding judicial transparency and live streaming or recording in the courtroom, and I think this is we know that courts have been streaming video or court proceedings for the past 2 years. That's been effective. The world has not ended. It is a needed way to bring more transparency into the process, to allow the public to know what is going on. It helps journalists because we're looking at wide swaths of data and trends across the state, and being able to kind of pop into various proceedings is important to understand sort of the tenor of what's happening throughout the state. So we do believe that this will increase transparency, which will allow the general public to engage more fully and to understand the court process. We believe it has some strong protections built in so that jurors are not exposed or alleged victims of sexual offenses. And so we would urge a favorable report. Thank you.
So thank you very much, Ms. Snyder. So seeing no questions from the committee, actually we have one question from Senator Watson.
Yes.
Just one question. So when I go to court for a crime, I'm going to be judged guilt or innocence, right? Mm-hmm. And why would you not want, if you believe in the transparency, would you support making the videos releasable after a guilty verdict is stated versus putting somebody out there who may or may not be innocent?
Mm-hmm. I think that's really a question for the sponsor, and I think the committee has to deliberate on these bills. You know, you've heard some that would require live streaming of all proceedings, criminal and civil. This one is particularly just one around criminal proceedings. Another is just on the sentencing side. So personally, or it's the us, I think when we get to, you know, you don't want to pile on just on the guilty. the guilty verdicts, I think that it's instructive and important to understand the process. So that's why I feel like if you're going to do it for one, if you're going to do it, only release the guilty verdicts, I think you should release the innocent verdicts as well, because there's a lot of steps in that process. And that's what we're really getting at, or from the Press Association standpoint, that's what we're getting at, to shine light on that process. It's not just to grind someone under the heel who's guilty, because that's wrong. We want to make sure that the proceedings are open and transparent.
Yeah, I'm just thinking of the potential misuse to be able to have access to that video. For example, I have to go to court to fight something, and I'm currently running for office. What could happen with that video to try to disparage me in public and those types of things, even before a guilty verdict comes out?
Now, I would note that these are open court proceedings in general, so if someone really had, like this vendetta, we are going after Senator Watson, they will sit in court.
They can sit, but they can't videotape. They
They
can't
can't
record.
video, but they could certainly sort of bring dispatches back from the courtroom. So I think that you'd be vulnerable in many respects if you're thinking about yourself as a public figure. But I think it's important for the process to be very open.
And you don't think, if you do this, you don't think it would politicize judges' appointments?
Now, I would hope not, because it's important for judges for people to understand the records, that prosecutors, witnesses, like everybody, it's not just judges who are being, broadcasted or live streamed in this situation. It's everyone in that courtroom, aside from jurors and victims of sexual assault. So everyone's record is available. And I would hope that it doesn't politicize it.
All right, thank you very much.
Anyone else?
Thanks, Mr. Chair. And thank you. It's so wonderful to have a constituent here, especially when we're on the same side of an issue. So just briefly, I wanted to point out that my understanding of the bill, I talked to Senator Hayes before you filed the bill. I was a part of an effort for many years when I was in the House of Delegates for legislation that never went anywhere, cameras in the courtroom, because I actually do think that these proceedings are important. I mean, we have court TV, we watch that all the time, but I had two quick questions. One, because I don't know, you may know, I know we did live streaming during the pandemic, and so that was more open than previous to the pandemic, but are there other places, other jurisdictions that have this use of the live streaming or the videos available?
Maryland's a little bit behind the time, and of course, the pandemic has changed a lot for many, many states. I cite in my written testimony a link to a pilot project that was done back in 2016 on the federal level to assess the effect of broadcasting or recording within the courtroom. And at that point, there were several states, there are certainly more now. I'll get some more specific information on exactly who allows, but we're not the pioneer here.
I think it would be helpful just, to look at other places where it may have been in existence for a while and see that the world didn't come to an end.
Exactly.
And it didn't interfere with justice. And then one thing about this bill is my understanding that, of course, there is a protection for jurors or witnesses, and also there's judicial discretion that attorneys could always motion and argue to the court if they had issues that they felt were particularly sensitive or should be kept more confidential, and the judge would have the ability to decide. Isn't that correct?
I'm not sure that that's written specifically into this bill, but I think it's an important distinction. When I read it, I didn't see judges' discretion, but I would imagine that's kind of assumed. Judges do have an enormous amount of discretion in their courtrooms. We do not have any quibble with that, because there are certainly situations which the judge might find that it's not appropriate, just as they would close a courtroom proceeding.
I think, so I would say that probably should, if it's not spelled out in the bill, it probably should be. I do think that is important, because they're not, beyond just protections of juveniles or jurors or specific witnesses, there are a myriad of things that could come up that really is in the best interest of my client, if I were representing someone, to not have it live streamed.
Oh, that makes sense. Appreciate that.
Thank you, Mr. Chair. So I find a portion of the Maryland Judicial Conference's opposition to be really compelling. I wanted to read it to you because you won't have a chance later on after they testify to come back.
Right.
So I don't want you to comment on it. So they say, broadcast coverage of criminal proceedings discourages victims and witnesses from participating in the criminal justice process. Victims and their families are often required to describe humiliating details of heinous acts perpetrated against them and are asked to reveal sensitive personal, medical, and psychological information. Defendants likewise provide testimony and evidence regarding personal details of trauma in their lives in mitigation or to establish their prospects for rehabilitation. These intimate details of personal humiliation and suffering have no educational value, and televising them can serve only to satisfy a prurient interest in the misfortune of others and for the commercial benefit of broadcast media organizations. How would you respond to that?
I would say that I imagine the judge would have discretion to close the courtroom, just as the judge has discretion to close a courtroom of a public proceeding. They say, okay, we're going to clear the courtroom because this juvenile witness is going to testify, or there's something particularly prurient. In general, I understand the concern. News media tends not to try and flock to those types of, tries not to make someone relive that moment over and over again, and I think there is sensitivity around that. It's something that we want to make sure that the process is transparent and there's accountability within the process, but also making sure that people's dignity is preserved. And I'm certainly open, it's not my bill personally, but I'm certainly willing to work with the sponsor to see what we could do to work through those.
Well, the
those
bill
concerns.
states the court shall make available to the public live video streaming of all public proceedings. So if the courtroom is open to the public, it would, based on this bill, there would have to be live streaming. So in order to protect these witnesses from humiliation, et cetera, your solution is to to exclude everybody from the courtroom, to stop the trial, make everybody leave the room, and then have the witness testify, and then once the sensitive testimony is over, bring everybody back into the courtroom again?
So that's an option. You could also go with Senator Carter's option, which is to spell out specifically that the judge has discretion whether or not to broadcast that video.
Okay, thank you.
Sir, there you go, Senator
Apologize
Carter.
for this, Chairman Smith, but just I want to do a quick follow-up with respect to Senator West's questions, because I don't, that's, what Senator West described is not my reading. When it says here that it would not include a juror or an alleged victim of a sexual offense, and I'm sure we could add to that list if necessary, I see it as they just simply wouldn't be included in the video. Not that the courtroom would have to be cleared, if the courtroom was not already otherwise cleared for some reason, if just that they wouldn't be visible on the stream. Is that, that's my understanding, not that.
I think that that's probably an area that we should clarify, because video and audio can be considered two different things. And I think the goal is, if the goal is transparency and sort of looking at the system as a whole, then we do want to make sure that we're protecting the vulnerable in those ways. That seems to be an amendment as opposed to, let's toss the entire bill out. That's an area to work together on.
Thank you so much. Mr. Chair, I'll volunteer to work on the work group.
That's the rule. All right. Thank you very much, Ms. Snyder. All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll have Chief Judge Morsi, Judge Braverman, and is Crystal Williams here? Yeah, there you are.
Thank you, Mr. Chairman, members of the committee. I am Senior Judge Nathan Braverman, and it's my privilege to be here on behalf of Chief Judge Getty, my Chief Judge Morsi, and the Maryland Judiciary in opposition to Senate Bill 758. I want to just make one note about transparency with all due respect to the authors of the bill. This is really not about judicial transparency. Our courtrooms are open. Our courtrooms are open to the public. They are open to the press, who are free to come in and report what happens there, what goes on there every day. What we're talking about is electronic broadcasting. As Senator Carter could tell you, we've been studying this issue, and she and I have been discussing this issue for a long time. The judiciary's been studying it since 1980, before live streaming was a thing, before there was something called going viral. And the issues we are concerned with then have been exacerbated since with the advent of technology. We published a report. There's a link to it cited in our the electronic version of our written testimony after 6 months of study. That included public hearings, that included written testimony, that included research. And we found that participants, all participants in the criminal justice process, prosecutors, defense lawyers, representatives of crime victims, and the bar generally are against this, firmly against having broadcast, and for good reason. Broadcasting criminal trials brings with it significant unintended consequences. Some of them Senator West pointed out from our position paper. There's a fear of retaliation. Again, without even getting into whether you're going to be broadcast or not, prosecutors will tell you we can't get witnesses to cooperate. We cited to an article that said 300 cases in 2018 were dismissed in Baltimore City because they could not get victims and witnesses to cooperate. Having these things broadcast can only make these matters worse. The video feed required by the bill will be used by commercial media. Obviously, they're here in support of it. And the commercial media has tended to distort rather than accurately report what happens in our criminal courts, often at the expense of minorities that are 2 times more likely than white folks to have their trials and tribulations reported in the media and on television. Citations to the data are in our report. They're in our written testimony. I urge you to take a look. If you disagree with the Maryland Crime Victims' Rights Council, and Kurt Wolfgang, who cannot be here today, authorized me to represent to you that they are still opposed. And the State's Attorneys Association, I don't know whether they're here today or whether they filed. They were with us for House Bill 10 across the street just a week or 2 ago, opposed to an even more narrow bill. But if you don't agree with all of the players, and the public defenders, the state's attorneys, and victims all agree this is a bad idea, then we'd have to take a look at this particular bill, which does impose an unwieldy and rather expensive, we say multi-million-dollar, up to $6 million burden on the courts, and encroaches at the same time on judicial authority to regulate procedure and ensure the fair and orderly administration of justice. I read nothing in that bill that gives a judge the right to limit testimony that the judge thinks should be kept private. It's not in the bill. It is in the Maryland rules covering civil proceedings, Maryland Rule 16-601 and the bills that follow. Moreover, this bill requires the live stream of all proceedings involving crime and violence, starting at bail review, when you hear just bald allegations and horrible things about defendant's background. It applies in preliminary hearings, one-sided affairs, defendant's not allowed to put on evidence. Every motions hearing, pretrial motion for suppression of evidence, needs to be live streamed according to this bill. Everything through trial and sentencing. Many of these occur simultaneously in our courthouses. Large jurisdictions could have 5, 6, 8 of these things going on at one time. That's going to require tremendous technology effort and manpower effort. We estimate $2.5 million for software licensing and storage. We're told $6 million for staff to set up, maintain, monitor the feed so that the faces of jurors are not shown, so that the faces of victims of sex crimes are not shown. Their voices can. It says nothing about protecting domestic violence victims. It says nothing about protecting child abuse victims. But even for the narrow exceptions, somebody's got to monitor them in real time, because we're talking live streaming is what the order is. Live streaming is what the mandate is. And so there's nothing that allows us to protect. If you want to see how that's done, look at Rule 16-601, and that series is how it's done in civil cases. So it does allow for no protection. So sensitive health data, of identity of an undercover officer. Boom, live stream. Could they somebody file a motion to try to protect it? Sure, but there's nothing in the bill as I read it that gives me as a judge the authority to say no. A question that Senator Watson raised earlier, about should guilt, the point is, you can't get it, once it's out there, you can't get it back. You can't expunge something that has gone viral on the internet. These concerns have, I know I'm running out of time, and I'll wrap it up. These concerns have historically been addressed by court rule. In answer to Senator Carter's question, there are, I believe, now 36 states that do allow some sort of broadcasting. There are 14 in District of Columbia, and the federal courts that do not. But they do it in a variety of ways, mostly by court rule, so that we can address the kind of questions that come up here really point to the reason that this needs to be done, ought to be done. If the mandate is thou shalt make some accommodations for to broadcast these things, ought to be done by court rule, the way, because the judges have traditionally and constitutionally authority to regulate the proceedings in the courtroom. We're governed by the Maryland Rules of Procedure. We have obligations to everybody to ensure the fair and impartial administration of justice, to protect privacy when necessary, when we can. But we can't, as was suggested, just close the courtroom. Defendant has a right to a public trial. So we can't just say, oh, the victim doesn't want to be heard. Under this bill, defendant can say, well, sorry, they're going to have to be. So there's a lot of fundamental issues with broadcasting these criminal proceedings where witnesses and victims are not there of their own volition. So generally, and then with this bill in particular. If there are no questions, I'll have a seat and yield to my chief. Thank you.
Good afternoon, Chair Smith and members of the committee, and thank you, Judge Braverman, for your remarks. I'll just kind of dovetail on to what he said. We trot out Judge Braverman every year because he was involved in a commission back in 2009, I believe it was.
7 and 8.
He chaired that commission, and he's really, truly an expert on these issues. But I can tell you we're revisiting all these issues right now in the judiciary. In September of 2021, Chief Judge Getty, who you know is the Chief Judge of the Court of Appeals, Maryland Supreme Court, and it will be on referendum this year as to whether we change that name to Supreme Court, so as they say, vote early and often, right? He appointed and tapped Chief Judge Fader of the Court of Special Appeals to create a new joint subcommittee. We have, I believe it's 13 committees of the Judicial Council, one of which is the Technology Committee that really is the hardcore, data and wiring and those type of things. And then the other is a committee that I co-chair, which is the Major Projects Committee that keeps oversight over things like MDEC and all the other big projects that we're running through the judiciary. So this subcommittee is comprised of members of those two committees as well as others. It has people from our IT department, which we call JIS, Judicial Information Systems. It had court administrators, the people that are there in the court doing the work every day. It has our elected clerks of court, our clerks from the district court, and of course judges. I'm a member of that subcommittee, as well as being a member of the Technology Committee and co-chair of the Major Projects Committee. This subcommittee, we've had multiple meetings during the fall and winter of this year. We've executed surveys both internally within the judiciary as well as externally to stakeholders and asked them about the use of what is going on with technology and what their experience has been as we've gone through this pandemic. And the purpose of this subcommittee is for reviewing the various innovations and adaptations employed throughout the judiciary during COVID-19 to determine which of them should be retained or tweaked or gotten rid of moving forward. We've also held 2 different public listening sessions with external stakeholders where we received input from the public, including discussions regarding video live streaming of court cases. We're currently in the process of creating a draft report that it's being circulated among the subcommittee members right now. And when finalized, that report will be taken to the Judicial Council for approval of the Judicial Council and the Chief Judge of the Court of Appeals. I would suggest to you all that the judiciary is the proper governmental entity to make the decision as to what is live streamed and what is not from its courtrooms. As there should be, the judiciary has given much thought, consideration, and has engaged with external stakeholders regarding live streaming and other issues regarding remote proceedings in the courtroom. I know you all are being live streamed right now. I'm being live streamed as we speak. But I'm hearing participating voluntarily. When you come to court, you're not. I'm not being accused of a crime where I may lose my fundamental right of liberty, and I've not been subpoenaed here today to testify, perhaps under the threat of contempt. As Judge Braverman pointed out, there are serious concerns regarding due process, witness retaliation, and the chilling effect of live streaming. Just because we can does not necessarily mean that we should. There are a lot of issues that surround this. We recognize that we needed to examine all of these issues in a holistic approach, and hence the work of the subcommittee. We really do believe that it should be the judiciary that decides this issue. Finally, as the fiscal note points out, this bill will have significant fiscal and operational implications to the judiciary. This is not flip a switch and every courtroom would live stream. There's a lot more to it in terms of equipment and what we're doing. It's one thing to participate in a Zoom proceeding. It's another thing to live stream that Zoom proceeding out. I'd like to thank this committee for the opportunity to present you here today, and I would urge an unfavorable report. Thank you, and I'd be happy to answer any questions that you may have.
Good afternoon, Chairman and members of the committee. My name is Crystal Williams, Director of the Government Relations Division for the Office of the Public Defender. I'm here today in opposition of SB 758, as our agency has long been opposed to the public broadcasting of criminal proceedings for a number of reasons. While our office understands and appreciates the importance of transparency and access to court proceedings as a means to ensuring a fair judicial system and holding that system accountable, providing live streaming of court proceedings, particularly those involving crimes of violence, in turn poses many risks and raises serious concerns for our clients and all parties involved. We certainly acknowledge that public access to criminal proceedings allows for the general public to act as a check on the legal system and ensure that it is functioning fairly and properly. However, this can be done through the current means of public access. Allowing for live streaming of all court proceedings involving crimes of violence presents immense concern for the dissemination of confidential and sensitive information, as well as real dangers with exposing permanent images and information that can not only improperly influence public perceptions and potentially taint jury pools, as well as be misused by those with ill intentions to impact live proceedings, but also creates a permanent record for anyone who may be later found not guilty or have their matter dismissed or eligible for expungement. In addition to the dangers of racially prejudicial media coverage, live streaming can also present real far-reaching concerns for the ability of anyone who is watching to post that proceeding on social media, record it, and alter it. For example, some of our attorneys have had trials during COVID, and the trials were broadcast in a space that was one room over from other family members. In one domestic violence case, the family members of the alleged victim recorded the trial from that other room and then streamed it on Facebook. It was viewed by other witnesses. Thus, there are real concerns about witness sequestration in any type of hearing, if I may briefly conclude, in any type of hearing where this would be at play. While this is a concern, even if the witnesses are in the courtroom, it is far easier to record proceedings when no one is watching you and preventing you from doing it and posting it on the internet. For those reasons and others highlighted in our written statement, as well as those expressed here today by Judge Braverman and Judge Morrissey, we ask for an unfavorable vote. Thank you.
Thank you very much. If I might ask either gentleman from the courts one question. The video recordings that are currently done, how does one access those recordings?
Well, they are done. They are for court use. They've not typically been disseminated. I think there's some federal litigation going on as we speak, still underway, as to to what extent the press should have access to those. But the general is they are not to be reproduced by court rule.
Okay.
They are for preservation of evidence,
Gotcha.
not for public entertainment.
Got you. And correct me if I'm wrong, but under this bill, if it's just looking to broadcast proceedings that deal with crimes of violence, would a juvenile waiver hearing be something that would be broadcast?
No.
It would not.
I don't believe it would because they're not crimes. A waiver hearing, well, no, until they're adjudicated.
Right,
But no,
so,
the
I
answer,
mean-
the answer, my understanding would be no. I'm certainly happy to take a closer look at that and let you know. But I do not believe so.
Okay, all right.
But it is a good question.
No, I mean, and I ask because I would think that if a juvenile is being, if a proceeding is going forward in the adult criminal system, until they're waived down to the juvenile.
Until they're waived.
Right, I mean, that,
Once they're waived,
Then
and tried as an adult for a crime of violence, as listed 14401, 201, yeah, then arguably yes. And certainly young people who are witnesses, who are victims, would be broadcast, which may be even worse than as a defendant, quite frankly. Because they're really, because you're an innocent victim and now you're testifying, you're telling your life story to the world.
and just one other question, because, I mean, I can certainly, I see both sides to this. I mean, I certainly was one who was glued to the television watching the Ahmaud Arbery case and kind of seeing how prosecutors do their job. I mean, we got to see a defense attorney use some really racist trope-type language in her defense of her client. We got to see judges do what they did. I mean, you look at Wisconsin and the trial that happened up there. So, I mean, there certainly can be some public or public good to these kinds of things. So I'm curious, and because you said you've worked on these for a number of years, have you all looked to these other states to see how they do it and how it could be done?
Absolutely, and I'll say two things about some of the recent things that we've seen. And one is, it does highlight, although in a slightly different way, the importance of race in what the media decides to cover. Because every trial, we saw some Minnesota trials, we saw some Wisconsin trials, but have you seen any other Minnesota trial?
Right.
Or any other Wisconsin trial?
Right,
Or even California trials other than O.J. Simpson?
right.
So it does illustrate that point, I think, rather poignantly. And second, and this had maybe a more beneficial, if you will, at least seeing what happened in Minnesota may have had a more beneficial. But just because every once in a while the media may get it right, doesn't account for all the times that they tried. They're really, I mean, they're commercial media. We understand it. They are broadcasting what sells.
Thank you very much.
Race sells, violence sells, and in this case, yes, justice sold. But just because it can, on occasion, be put to a good purpose, it doesn't cover all of the times where it is. And yes, certainly we have looked at the 35 or 36 different other jurisdictions that have done it, including some that have started with the experiment, like New York, and the legislature said, no, this isn't working, this is not good for justice.
Thank you.
And stopped it. Thank you.
Yes, if I may just briefly respond to Senator Sidner's initial question to Judge Braverman, just to add a point of clarification. I know your question was regarding waiver hearings. Waiver hearings are those that start currently in the juvenile system. Reverse waivers or transfer proceedings are those that start in the adult system. Those would be subject to public broadcasting. But the juvenile waivers, I don't see anything in this particular bill that would protect that, but confidentiality is of primary purpose for the juvenile court proceeding, and I would imagine that there would be something that would need to be put in place to protect those proceedings. This assembly has also already passed legislation to protect the public distribution of case information on those that are eligible for transfer or reverse waivers that are currently in the adult system right now. So there is an effort to protect those children, but this particular bill would not protect them. Thank you.
All right, seeing no additional questions, thank you all very
Thank
much.
you.
Thank you. Thank you. And with that, that will conclude the hearing for Senate Bill 758. We'll now move on to Senate Bill 759. Senator Hayes.
Hello, again, I am not Senator Hayes. He is currently on paternity leave, but I am just reading his testimony on behalf of him. So, Senate Bill 759 is the Real Property Ground Rent Redemption Fund establishment. So for majority of the last decade, Baltimore experienced a larger drop in home ownership than the national average. The reasons for this decline include a lack of investment in safe neighborhoods and the inability to compete with real estate investors who buy houses in inexpensive areas with cash. These barriers are even more significant for potential Black homeowners. Disproportionately, lower loan acceptances additionally hinder Black home loan applicants. Shockingly, Maryland is one of only 3 states that still follow residential ground rent policies, and Baltimore is the epicenter of the practice in Maryland. As a result, homeowners risk losing their places of residence if they cannot pay the delinquent ground rents they were previously unaware of. Senate Bill 758 would create a fund to alleviate the burden of ground rent for those who cannot afford it and may be at risk of losing their homes. This fund could even allow homeowners to buy the lease and exempt them from any further ground rents related issues. A July 2020 report by the Able Foundation also suggested building financial support systems to prevent further decline in home ownership in Baltimore. This bill will establish a non-lapsing fund to ensure that only those who need financial assistance are provided the grants. Therefore, this bill could stabilize the growing disparity caused by ground rents between residents of different economic and racial backgrounds. This bill has significant potential to mitigate the detrimental effects of outdated practices. We also have an amendment that will address some of SDOT's concerns in their letter of information because they said as drafted, it did not accomplish what we were trying to do. So one of the amendments would apply this only to residential property. Another one of the amendments will make this, so currently it's a 30-day wait period when you apply for this program through SDOT. It's just 30 days. It's not waiting for anything. So the 30 days will apply to sending the ground lease holder a notification that you are trying to redeem your ground rent lease. So you send it to them, and then you have to wait 30 days. They don't have to give you a response, but as written, you have to wait 30 days. There's no reason for that. So we take that part out. And then also, there is a 90-day period to wait to send your money. So right now, as written, you can collect your ground rent up to 3 years prior. So once you send your application to SDOT, you now have to, it has to be posted on their website for public notice for 90 days. During that 90-day period, you still have to wait to send in your monies. So this part will take the 90-day period out to send the check because currently, if you send your check on day 87, SDOT is required to cash that check, but they are required to decline it because of this stipulation for the 90-day period. So you have to wait to get a refund from the state, which could take months, and then send your money again. So that would just take out that stipulation. And those are kind of the summaries of the amendments. So I urge a favorable report on Senate Bill 759. Next, I have Nika, who is one of our witnesses. She is with the Fight Blight Baltimore, and then she will give testimony. And I also have John Kern here, who is from the SOS Fund. He's not giving testimony, but he's here if you have questions.
Good afternoon, everyone. Again, my name is Nika Namdi. I'm the creator of Fight Blight Be More. We are a social, environmental, and economic justice initiative aimed at remediating blight, led by the village and informed by the data. In a part of my work, one of the things that we have been working on is a reparations and land sovereignty platform that explicitly deals with issues that have eroded Black home ownership and Black land ownership in Baltimore. And one of the things that we found is that ground rent is a vector for Black land law or Black home loss. And so we definitely are here in support of Senate Bill 759 59, because just like tax sale, we understand ground rent, condemnation, and demolition policy set at the state, local, and federal level has undermined the ways in which Black people house themselves, especially through homeownership. We support this bill with an amendment, with amendments to include a report analyzing the impact that ground rent has had on Black homeownership, and specifying guidance for DCHD on how to develop the means test and implement the program, because we've seen challenges, for example, with how DCHD is handling the rollout of the Homeowners Assistance Fund, which is creating barriers for some of our most vulnerable homeowners. Again, we support this bill with amendment, and we ask for it to have a favorable report.
Thank you for your testimony. Are there any questions? Senator Carter?
Thank you, Madam Chair. I just wanted to say, Ms. Namdi, thank you for your work. I saw you in the film by Sean Yo's Disruption, and I really appreciate all that you do. Thank you.
Thank
No
you.
questions.
Thank you, Madam Chair. So I guess my first question is, does anybody have a handle on how much it would cost to redeem all outstanding ground rents in the state of Maryland?
I do not have that answer. To be honest, I have been asking for the last 5 years. I have been asking SDAT for a listing of all the ground rents so we could conduct our own analysis to answer that question. Also to answer questions like, where are the remaining unredeemed ground rents? And I was told on several occasions, even up until last week, that the State Department of Assessment and Taxation does not maintain a list or does not maintain a publicly available list of ground rents. So I can't answer that question for you.
I can give you another answer.
Yes.
So I actually talked to SDAT yesterday, and their system is very old with like zeros and ones. So with their current capabilities, they're not able to compile a full list. Currently online, if you just Google SDAT ground rents, they have a website, and you can type in any address and see if there is a ground rent and see the history of it, but there's no compiled list. They do have a list of all the redeemed ground rents, so I think there's like 127 pages that you can look up online right now, but not a current list of all the outstanding ground rents.
Because I believe a couple of years ago, we passed legislation that provides that in order to maintain ground rent, you have to register.
Yes.
So before that, many of these ground rents, most of them, were not registered. They were simply embodied in deeds, which had been executed in 1889, long, long ago. You can't create new ground rents in Maryland, so we're talking about working off an old problem. I would think that it shouldn't be that hard for SDAT to compile a list of those who have registered.
I agree. That's a part of one of our amendments, just to make sure that the ground rents, to qualify for this grant, you have to be registered with SDAT. So currently, there are some people who send out notices and they're not registered, and you can't really trace them, and SDAT can't hold them accountable. There's no action that can be taken when you send out those notices and it's not from SDAT. So in this bill, in the amendment, we made sure that you have to be registered to SDAT.
Okay. I don't see any amendments, so I guess we're going to have to get a hold of those, so.
Yeah, I sent it to the committee analysts, so it
Okay.
should be
So,
in the
well,
system soon.
One of these days we'll receive them. I guess my thought is this has been a long time issue in Maryland. I'd like to get a handle on the problem as a whole. And maybe instead of this bill, what we should do is do a work group to work in the next summer and work with SDAT to find out exactly what we're talking about here, and then craft legislation for next year that can solve the problem.
Yeah, I'm sure Senator Hayes will be open to that. I'll definitely mention that to him.
Great, thanks.
Thank you. Senator Casserly?
Yeah, further to what Senator West was discussing, looking at SDAT's comments, it appears that, from what I understand they're saying is, there's a lot of these things that are basically, for all practical purposes, dead. Nobody's pursuing them, but once they realize there's $20 million sitting out there, a bunch of people are going to come register to try to make some money off of this fund. People who had considered their ground rent for practically dead, didn't register, would now register. So I think that would be a concern. I'm totally, the whole ground rent thing, I'm not, it's a idea whose the utility came and went about 100 years ago, but we're still dealing with. So I'm not against what you're trying to do. It seems like we got to come up with something that doesn't take a fund that encourages people to now register. It's an item that was devoid of any value, and now all of a sudden we gave it a value. We're going to give state money out. We're going to place a
So-
value on it, and that would be a problem.
Currently, you're only able to collect ground rent 3 years prior, so that's as much as you can get. That's why I think it's capped at $3,000 right now, because that's as much as you can get. Then after that, that's like just the cap.
Right,
So if you're trying to collect from 10 years, it's not possible.
right.
But it's also, to be clear, it's also, yes, the sharks are gonna be in the water, but the sharks are in the water whenever development starts to happen in many of these communities where there's a preponderance or a concentration of ground rents. So those are a lot of the old neighborhoods in Baltimore. So whether they come out of the water today for state money or tomorrow for an elder's home is the matter of weighing, right? So they know that there's an opportunity to foreclose if someone isn't able to pay. So whenever it becomes advantageous for them to come forward and collect, even if it's only back 3 years, $3,000 may not be an issue for you or I, but I can guarantee you there are people sitting in homes that they've owned for, several decades who $3,000 is going to make a difference for them. And if a developer or ground rent holder now wants to take that property from them, they can just come simply ask for that $3,000.
But you're not, this fund wouldn't just be paying the background rent. Oh, this would purchase the entire ground. And then how is that valued? Is it a set value already? How do you value a ground rent?
SDET has a formula based on, I can't really tell you.
Okay,
but
there is a formula for what they would redeem a ground rent for.
There's a formula, it's 16.6%, so, yeah, for what they're paying annually.
Okay.
So they use that formula to establish what they could pay off. That's the redemption amount that we say. But the ground rents that go back older than 1889, you can't use that formula. So then you have to just negotiate with the ground holder in order to redeem, which again is another barrier for older folks, who already, this is a very cryptic system, and they're on the phone with somebody from Florida trying to negotiate what that amount's going to be.
Right.
So.
Okay. Thank you.
Are there any other questions? All right, thank you.
Thank you.
That will conclude Senate Bill 759. And we will now go on to Senate Bill 815. Senator Lee.
Madam Chair, may I bring up some of my panel right now? Panelists, come right up here, because they'll be able to answer some questions because they were the lead counsel in a case that's going to be referenced in this bill. Today I bring you SB 815. This bill is a response to the Reeves decision handed down last summer and the nonsensical limitations placed on Maryland courts when faced with a tortious injury or loss of a pet. Includes the reckless standard of gross negligence, malice, intent, or violation of a citizen's constitutional rights. The bill in no way is aimed at veterinarians, which we have communicated to numerous offices, including the American Veterinary Medical Association and its Maryland counterpart. In fact, the bill is specifically designed to avoid increases of insurance premiums, as we are confirming that those policies would not be available and shouldn't be due to public policy concerns. The non-economic damages are only available if there's a standard of intent, malice, violation of a constitutional right, or gross negligence, and these do not arise during veterinary procedures. The Maryland Court of Appeals handed down the Reeves decision last summer. The facts of the case are that an Anne Arundel police officer, while canvassing for burglary-related information, entered the Reeves property, knocked on their door, received no response, and then moved to the driveway. The family dog named Vern approached the officer at the time, barked just once, and placed his front paws on the officer, and the officer unfortunately shot Vern twice, killing him. Mr. Reeves was awarded over $1.2 million for a violation of his state constitutional rights, gross negligence, trespass to chattel, and gross negligence. Because of the TCA, the award was reduced to $200,000 and further reduced to $7,500 under Courts and Judicial Proceedings, Section 11-110. And one injury, one recovery rule. No award was made for the constitutional violation. The court reviewed our legislative history, the plain language of the law, or continued silence on non-economic damages, and acknowledged their hands were tied because of the cap and our limiting of duplicate tort damages under Section 11-110. Mr. Reeves received less than would have likely cost for a couple of days in critical care ward of a veterinary hospital to save Vern if the shots were not lethal. During the discussions of raising the Section 11-110 cap in 2014, our very own Senator Huff marveled that we allowed so little for pet damage recovery while any other form of property has no similar cap. Should a Van Gogh worth $3 million be destroyed, the plaintiff is likely able to receive the full value in damages plus potentially non-economic or punitive damages should the painting prove to be of great sentimental worth or similar. Yet our pets do not elevate to the status of a painting, even with the language of this bill, because the cap still applies to compensatory damages at $10,000. Unless the element of malice, intent, or recklessness is proven, non-economic damages do not apply to pet deaths or injuries, even where there's a clear case of negligence. I just want to highlight a hypothetical brought in the Reeves Court of the Special Appeals dissent. Say a person turns into their neighbor's driveway instead of their own due to texting or other distraction, therefore negligent, even potentially grossly negligent. If you hit a car parked in the driveway and proceed to smash the garage door, which in turn falls onto a pet rabbit, causing injury under the current law of Section 11-110, the homeowner's recovery is capped at the cost of veterinary care of the rabbit and precludes recovery for damages to the car or garage door. This is illogical and nonsensical, but it's a status quo right now in the law of the land in Maryland because we have a legislature that's not been very clever enough to get around the concerns of vets in this space. Once more, we have crafted this bill in a way that courts have the ability to award non-economic damages during specific moments. I want to highlight gross negligence, which seems to be the main concern of the veterinary community. We have heard that there is a thin line between negligence and gross negligence, but I want to indicate that all involved in gross negligence is the intentional failure to perform a manifest duty in reckless disregard of the consequences as affecting the life and property of another, and also implies a thoughtless disregard of the consequences without the exertion of any effort to avoid them. And I do have faith in veterinarians that should a failure occur in some manner, that there would be effort to fix the failure. I've already discussed carving out the veterinary community with our advocates, and I hope that has been conveyed to the doctors who testified today. We've also communicated with the insurance community, and they agree you can't get insurance for intentional torts or malice, but think that the gross negligence threshold may be an issue. But that, most importantly, it sets a new precedent. We heard from other opponents whose concern is a slippery slope to animal rights. The bill does not give animals rights, and if someone is grossly negligent, it should be the policy of our state that tortfeasors pay for those damages instead of the innocent victim. And we, as you know, we have contributory negligence in Maryland, so we truly are setting the stage for victims to be re-victimized. I respectfully ask our committee members to vote favorably on SB 815. I'd like to turn it over to my panelists who will answer your questions.
Thank you, Senator Lee, and thank you, Chairman Smith and members of the committee. My name is Kerry Hansel. I'm a civil rights lawyer. I've been practicing law in Maryland for 20 years. Under current law, there is a $10,000 hard cap on pet damages in all but the rarest of circumstances, and that effectively means that there is immunity, because that's not a sufficient cap to warrant the exercise of a lawyer's time and the efforts to bring a case to fruition. This steps that back by taking a very small baby step. So what it says is that cap will not apply in the extreme circumstances of gross negligence, intent, constitutional misconduct, or malice. And Senator Lee read the standard for gross negligence, but it is very high. It's an intentional failure to perform a manifest duty in reckless disregard of the consequences. It also has to include a thoughtless disregard of the consequences to anyone and no effort to avoid them. So this isn't the type of behavior against our pets that we would want to immunize. Nobody would stand up to defend that. The same is true of intent. The same is true of constitutional violations or the use of malice against pets. So why should we continue to effectively immunize that type of conduct by having such a low cap? Now, with respect to constitutional violations and malice, those are codifications in this bill of existing court opinions, Brooks versus Jenkins and Anne Arundel County versus Reeves. It is intent and gross negligence, which are the key. Those other two need to be in there so we don't inadvertently overrule those opinions. This is not a veterinary bill, because I don't think our vets are going to stand up and tell you they want to intentionally hurt animals. They aren't capable, because they aren't the government, of violating their constitutional rights. I don't think they want to act with malice or gross negligence, and so it is not a question for vets. If I may briefly proceed, thank you. I want to let you know very briefly about the issue in Maryland and how widespread this is. The Department of Justice has said nationally that it is an epidemic. 10,000 dogs are shot nationally every year. In Maryland, in one county where we have litigation, there are 2 shot every single year who have not touched an officer, not touched another human being, and are on their own property. So this is a desperately needed change also as a police misconduct measure. The Reeves case happens to be a police case, and I would urge you to vote favorably in connection with this, vote this out of the committee favorably. I wanted to also briefly mention I'm here for myself personally, for the Maryland Association of Justice, and the bill is also supported by the Maryland State Bar Association Animal Law Section, who has submitted written testimony. I'm happy to answer questions in connection with the bill.
Excellent, thanks. Well, Senator Lee, I know the former chair of this committee would be proud of you for this bill, but I don't know what, I don't know what that portends for the fate of the bill, but, all right, so we'll go with Senator West and then Senator Cassidy.
Sure.
Thank you, Mr. Chair. So I'm interested in the word intent. In the Reeves case, the officer obviously intended to shoot the dog. Let's vary the facts of Reeves just a little bit. Suppose the dog had come up and bitten the officer, and the officer shot the dog. The officer still would have intended to shoot the dog. So intent seems to encompass an awful lot of conduct.
But it has to be an intentional tort. So in that case, it would not be a tort at all. In other words, we're talking about, if you look earlier in that paragraph, we're talking about a tortfeasor. And then if you look at the rest of the statute, it applies under B1 to a person who tortiously causes an injury or death of a pet. So this would be an intentional tort, a constitutional tort. So we would have to make out all of the elements of a tort claim first and show that it was intentionally done. In the case where the dog bites him, that's not a case. I mean, in other words, the officer would win that. He wouldn't need to win it because nobody would take it. I mean, that's, any lawyer would look at that and say, it was in effect a good shooting, a clean shooting.
Okay, well, it's been a long time since I took torts. I'm going back 50 years. So intent is not a part of the normal tort. You don't have to prove intent in order to establish a tort. You have to establish that there was an injury, an act that resulted in injury to someone. And so.
So there are, Senator, there are intentional torts and non-intentional torts.
Yes, of course.
When we sue, for instance, a veterinarian, which in the past has been the roadblock, the stumbling block to making positive change here, if we sue a veterinarian, that's a negligence action. That means there's a duty and a breach and damages. Medical malpractice, veterinary malpractice would be negligence. That is not intent. And so intent is somebody intends to commit the tort,
Right,
and
well-
not just intends to pull the trigger, but intends to pull the trigger knowing they have no right to do so. And likewise, constitutional claims are intentional. Malice means the jury has to find you act with an evil or rancorous motive. And then gross negligence includes an intentional failure to perform a manifest duty in reckless disregard of the consequences. Again, that's not a veterinarian doing his best and making a mistake. That's elements of intent, of recklessness. It's an incredibly high bar to meet in a court of law. So that's why I said this is only a baby step. We're peeling back only the first layer of the onion and asking that the most atrocious misconduct. And in the Reeves case, it's a great example. The officer lied, and the court found that he lied. That's not coming from me, that's coming from the court. He says the dog jumped up and attacked him. The jury found that didn't happen, it wasn't true. We had a veterinary expert that talked about the path of the bullets. The officer says with the dog up like this, he shoots it in the stomach. Instead, the dog, because the path of bullets is down on the ground away from the officer. You know, things like this. So we're not talking about a situation in which anybody here would defend the conduct.
No, okay. So, but it sounds like what you're drawing distinction between what happened in the Reeves case, where the dog came up, barked, and put his paws up on the officer, and the officer shot the dog. That would be intent. But if the dog came up and barked and put his paws and tried to bite the officer, and the officer shot the dog, that would not be intent.
Well, it's
Sounds
not-
like that's the distinction you're drawing?
It's not the element of intent. The intent in the sense of pulling the trigger is the same either way. I agree with your point in that regard. What is different is it has to be also a tort, because the earlier part of the statute talks about tortiously causing injury and being a tortfeasor. So I have to prove all of the elements of a tort. So for instance.
So in this, I'm sorry to interrupt, but in this case, therefore, if the dog put his paws on the officer and the officer shot, that would be a tort on the part of the officer. But if the dog put his paws and tried to bite the officer and the officer shot the dog, that would not be a tort.
It may or may not be dependent on a jury, and that's why we trust these things to juries. The question would be, the simple question for the jury would not be, was it a bite, not a bite, paws on, paws off. The simple question for a jury would be, was it reasonable that the officer shot this dog?
Okay.
If the dog is snarling and has his paws on him and looks like he's about to be bitten, the jury may well find that that's reasonable. And then it's not a tort, and the element of intent doesn't matter, because it has to be both. It has to be a tort and either intentional, malicious, or a constitutional violation under this change. And we trust juries with that type of determination all the time. But in a police shooting, the ultimate question, and obviously I'm simplifying because, we don't have, we don't have a semester for a constitutional law class, but simplifying, the fundamental question was it reasonable? And so it's not a question of the dog did or didn't bite or did or didn't put, because it might be perfectly reasonable to shoot a dog that's nowhere near you, because it's a, big vicious looking dog, you're on a drug raid, it's being intentionally sicked on you, somebody's yelling sick 'em, and it's racing across the yard at you. Then a jury could say, of course, that's fine too. So we're not drawing the line at the particular conduct. Instead, there has to be a tort found, unreasonableness in this case, and then fundamentally, and then also one of these other elements. So we're talking about very atrocious misconduct, intentional, malicious, grossly negligent.
Okay, thank you.
Actually, I don't agree with the way you're reading the statute, the bill here, because it sets up two classes of defendants. The violation of constitutional rights can only apply to the state, right? The Maryland Declaration of Rights doesn't apply to the people around me, it's only to the state. So under this bill, what it says is, if I'm not a state actor, then I would have to act with gross negligence, intent, or malice, if I do those, then there is no limit. You could get $1 million because I killed your dog. You can get non-economic damages, you can get $1 million, you get $10 million, $100 million because I kill your dog.
So that isn't the case, Senator, because there are other caps that come into play.
Okay, the
So
normal
for
caps on
instance,
torts.
That's correct.
Okay.
So for instance, there's the
But
general.
you can get a lot. You
So
can get
for
a lot.
instance, there's a general non-economic damages cap. If you are an officer, for instance,
But if you are an officer, it's different though, because what it says, if you're an officer,
Right.
now we go into violation, or in violation of Declaration of Rights. So for a police officer, it would just be simple negligence. All you'd have to show is simple negligence, because that's a tort. It says it's a tort.
No, Senator, because for violations of the Declaration of Rights, they must be intentional. There is no, the case law is, there is no negligent violation of your constitutional rights. When I stand before a jury to prove a constitutional violation, I must prove intent, and there's, in most cases, and again, we're not here for a full semester, but in most cases, there is both a subjective and objective element I must prove. So I must prove the officer knew
Yes, but
that
the
he was
officer
intentionally violating someone's rights,
Yes,
not
the
just
officer
intentionally.
intended to deprive you of your your property, that was a dog. The officer intended to shoot the dog because he felt threatened, and now it's a simple negligence test. So a simple negligence test said this officer intended to shoot the dog because he feared for his safety, and now why is that not a negligence test? Because he intended to take your property.
Because to make a constitutional claim,
Uh-huh.
you're applying intent in the wrong way. It is both a subjective and objective standard, which means not that he meant to pull the trigger, not that he meant to shoot the dog, but that he meant to violate your rights, meaning the officer must know that he had no right to pull the trigger. If he had a right to, if he was reasonably scared, or if the jury finds the shooting was reasonable or appropriate, then this does not apply.
But it gets right back to a negligence standard then, because the jury, all you gotta do is have the jury believe it's a subjective. If the jury believes that the officer was not afraid, he intended to kill the dog, and the jury says he wasn't reasonable, I didn't think the officer would be afraid, so you get your full damages.
Senator, the best way I can answer that question is I will get you no fewer than 20 cases that say that there is no constitutional violation for negligence. It doesn't happen. It must be intentional. Every constitutional case says that, so it is not a negligence standard. I have to prove that the officer knew that there was a constitutional right at issue, knew what that right was, or else it falls subject to immunity, knew he was violating it, and did this anyway without any justification at all. And so, yes, when an officer walks onto your property and murders your dog without any justification, and the jury here specifically found the dog had not attacked the officer, and there was no justification for the shooting. In
Do we have
cases,
is there a plague of that going on right now? Do we have just
yes,
cops murdering?
the
just
Department,
cops are just doing that.
the Department of Justice has called it an epidemic. I can
In
send you
Maryland,
that
in
report.
the state of Maryland, we have a
Yes.
epidemic of people killing dogs.
I currently in my office have 6 cases. Anne Arundel County, which is a county I recently investigated, between 2002 and 2013, shot and killed more than 2 dogs a year where the dog didn't even touch anybody, and on the dog's own property. So your dog is in your yard, the police show up, it doesn't touch anybody, and the dog gets shot and killed. The dog in the Reeves case was the Maryland state dog. It was a Chesapeake Bay Retriever. The man whose dog it was a vet. He'd taken a year off to train that dog. And he wanted to do jumping competitions and all these other things. A Chesapeake Bay Retriever, for those who don't know, it's like a darker colored lab. I mean, these are sweet, cuddly dogs. So there is an epidemic. The Department of Justice has held so. Our case in Reeves
Maryland, the
demonstrates that.
Department of Justice has looked at the state of Maryland and said, my God, I'm just surprised the Department of Justice is out defending the rights of dogs. That's what just troubles me. I'm not sure why they're doing that. But you're saying in the state of Maryland, the Department of Justice looked at our state and said there's an epidemic.
Senator, that wasn't what I said. What I said was the Department of Justice has found nationally.
Oh, because I'm not worried about it. We're just a Senate in Maryland.
So in Maryland, as I told you, there's the Brooks case, which is a reported decision. There's the Malcalvo case, which you can look up online, which was settled. There's the Reeves case, which was a reported decision. I have 6 in my office right now, which I can send to your office. And I have in Reeves, in the Court of Special Appeals right now, there's a brief and a record extract that goes through 27 different dog shootings over this little tiny period of time just in one county in Maryland where the dog did not touch anybody. I don't mean just hurt, didn't touch anybody, and was on his own property and was shot by police officers. So yeah, if that's more, just look around the table here. That's 3 dogs for every person seated on this committee. So yeah, if 3 dogs for every person seated on this committee are shot and killed on their own property for not touching anybody, not biting anybody, not scratching anybody, where the call did not involve the dog. You know, in Reeves, there was a burglary 4 days earlier down the street. Nice residential neighborhood. They have no reason to have a heightened awareness or concern. They go and knock on the door. This Chesapeake Bay retriever comes bounding out, and the officer shoots it. Lies, as the jury found in his report about it, lies as the medical the veterinary examiner found, according to how the shots were fired. The jury finds constitutional violations, gross negligence. We fight that case for years with experts to try to save the next dog.
Is it a crime for someone just to go and shoot someone's dog without any cause at all? Can I just go by on their property and shoot their dog? Isn't that a crime?
You know, interestingly, under Maryland law, if the dog isn't registered, it may not be a crime. That argument is currently being made against me in these cases, that if you don't have the tags on the dog, it is under Maryland law, I forget the designation, but it's basically a loose dog and can be destroyed. And so there are police officers in Maryland in court today arguing that, yes, if you haven't registered with the county, they can walk right up on your yard and shoot that dog without criminal or even civil liability. And I can send you those cases. I'm litigating them as we speak. There's a pending motion to dismiss on that point precisely. So yes, there is an epidemic in Maryland. This is a massive problem.
Yeah. It's just, I mean, I've been a senator for a year and a county councilman. No one's ever brought
There's a reason for that.
Unjustified dog shooting.
There's a reason for that, sir. Most lawyers turn these down because of this
No, I
fact.
mean, citizens have never complained to this.
I'm sorry to tell you, sir, but the citizens that this happens to are not people who can take a day off and be here. That's just true. It doesn't happen to people who have the privilege to be here and spend time doing what I'm doing. The people, and that's why they're not here today. I'm not making this up, sir. I will send you anything your office wants to back up every word I've spoken. I will send it to you. I promise you this is a problem. If you will give me a day, I will come to your office. I'll have to make videos because these are people who work 2 jobs.
I see some police reports or something. I've never heard of one of these.
Enlightening exchange, but we've got to move on.
You have my word, Senator. I will send it to you, I promise. And I really genuinely appreciate your consideration. I do.
I appreciate this. Thank you very much. All right. See no further questions. We'll move on to the next panel. And so I think that concludes the testimony for the proponents of the bill. We'll now switch off to the opposition panel. We'll move on to Dr. Brooks, Kent McClure, Dr. Krueger, Dr. Silcox.
I registered. Can I join the panel here? Is it easier if I do that?
Well, good afternoon. My name is Dr. John Brooks. Now, I've got a testimony submitted script, and I'll try to stick to it, but this ain't my style, but I'll certainly try to give you my insight. I've been a practicing veterinarian in the state of Maryland for almost 49 years. I'm getting my 49th year in practice now. It's a misprint in this thing here, but that's all right. I gained 4 years. Throughout this time, my number one priority has always been, and will always be, working closely with my clients to provide the best care for their animals that fits with their finances. I have real concerns about the effects that this bill will have on the veterinary profession and on our ability to deliver affordable veterinary care. Specifically with the number of owners that will postpone or forego veterinary care because of increased cost. Every day in clinics throughout Maryland, veterinarians have conversations with their clients about the care that is needed and the cost of that care. These conversations often include prioritizing the various damages and aspects of care to meet the client's budget. With the introduction of non-economic damages, cost will, without question, go up. First, in a manner analogous to the defensive care practiced by physicians, it will make harder to scale care to work with what a client can spend than with desired outcome. And when those recommendations will be second-guessed in the event of a complication or less than the desired outcome, it places the veterinarian in a difficult situation. Litigation costs will also increase. Those costs will be passed down to everyone. At the end of the day, it's an end-user circumstance. With veterinary medicine being paid for almost entirely out of pocket, this has certainly potential to keep animals from getting care they deserve. I don't support a policy that will simply add another layer of cost and prevent animals from getting the care they need. And while I've still got a few seconds left, I'll give you a little insight. It's not a week goes by that I don't deal with where we have to make decisions on the economics of health care with the client. Particularly, I see the senior citizens, the widowers or the widows who come in with a pet that may be their last connection to the one who's passed. And I have to try to make a decision on how best to manage that medical care when I know they have fixed incomes. If I have the burden of an excessive increase in my malpractice insurance because of non-economic damages, provides me with a much, much more difficult opportunity to do what I do on almost an everyday basis. And that's to basically make adjustments for what I want to do, and that's to always, always have the human-animal bond as part and parcel to what has driven me over these last 49 years. I also worry that it'll make veterinarians more likely to practice in places out of the state of Maryland. Our Virginia Maryland College of Veterinary Medicine produces about 110, 120 veterinarians every year, a lot of which are our Maryland graduates. When they see the burden of an already elevated education and then look at the increased burden of a maybe 10 or 100-fold malpractice insurance, they're going to look elsewhere because it's just one more cost to layer to it. So I'll leave it at that. I ask you to look unfavorably on this bill. Sometimes unintended consequences make it something that we need to pass on. Thank you very much.
Thank you very much, Mr. Brooks. All right.
Good afternoon. My name is Dr. Robert Silcox. I'm a partner at Hickory Veterinary Hospital in Forest Hill, Maryland, and have practiced veterinary medicine in Maryland for over 20 years. Rather than repeating a lot of the same sentiments that Dr. Brooks just kind of went over, which I agree with wholeheartedly, I would also add that I have had the unique experience of being on the board of Harford County Humane Society and serving as one of their volunteer veterinarians for over 10 years. This bill, by interjecting non-economic damages to pet litigation, will ultimately not only harm pets and their owners by increased costs that Dr. Brooks pointed out, but will also end up harming shelters, rescue organizations, and others in the veterinary industry and animal care services. This bill will have impact on veterinarians or volunteers who help animal shelters and rescue organizations that provide low-cost spays, neuters, veterinary services by adding that greater liability. Veterinarians will be reluctant to volunteer for these organizations because of this risk that this new legislation would present, and that could very well result in animals not receiving their necessary care. This takes a much-needed volunteer resource out of the community. And then I would just, again, reemphasize what Dr. Brooks said. Right now, there's a shortage of veterinarians in the state of Maryland. We have a hard time attracting veterinarians back to community practice to help with the burden of the increase of pet ownership in the state of Maryland over the last 2 years that we've seen. And if there is a decision that needs to be made based on whether I can afford my malpractice insurance in the state of Maryland or somewhere else, I may choose somewhere else. Thank you for your time.
Good afternoon. My name is Dr. Jennifer Krueger. I'm a small animal practitioner from Olney, Maryland, and I've practiced veterinary medicine for about the last 14 years now. I'm also an active member of our national association, the American Veterinary Medical Association, and I serve as one of the 2 delegates for the state of Maryland to that national association. Veterinarians in Maryland, as these guys have said, have sworn to protect the animals we care for and work in partnership with pet owners to provide the best possible medical care available, but at a reasonable and affordable cost. Permitting non-economic damages as an award would potentially impede our ability to extend the flexibility to our clients and may decrease access to especially life-saving care for some pets. I have also, or I should say, I've worked extensively with not only the general public, but also many animal rescue organizations, including the DC Metro Transit Police Dogs and the Wounded Warrior Canine Connection Dogs. And this is to provide especially affordable specialty surgeries and preventative care to these pets. The passage of this bill could easily impact my ability to continue to help these organizations due to the potential of incurring, again, a much greater liability risk for us. Veterinary care in Maryland right now is affordable and really needs to remain as such. The possible negative consequences of awarding non-economic damages would be significant, and it would likely drive up the cost of veterinary malpractice insurance, and that cost would then be passed along to pet owners. Many people, as we've said, really only have a set amount of finances they can spend on their pet, as much as they would like to do more, and so higher prices would cause some owners to have to forego that care for these beloved pets. And so just kind of restating what these guys have said, we're asking that you look unfavorably on this bill. Thanks.
Good afternoon. My name is Kent McClure. I'm a veterinarian with the American Veterinary Medical Association, and I'm also here with the Maryland VMA. We oppose the proposed expansion of non-economic damages into litigation involving pets. People love animals and are very sympathetic to pets, seemingly more so than people at times. In a case in which the Iowa Supreme Court refused to allow these damages, the expert in the case testified that they could be as high as the national debt. The changes proposed by the bill would also lead to some strange outcomes. Who is the owner of a pet? It's not defined. Is it one person? Is it an entire family? When the damages are limited to economic measures, it really doesn't matter, as they can only be compensated once. This potential multiplication of claims is likely one of the reasons Maryland has previously drawn very strict lines on the recovery of emotion-based damages. What is a domesticated animal? It's not defined. The Maryland Code addressing commercial feed includes goldfish amongst a non-exhaustive list of domesticated animals. The proposed bill would drive cases to be skewed to arguing for gross negligence. A plaintiff could potentially obtain a capped non-economic damages award for negligence or an unlimited award for gross negligence. Litigants would have a very strong incentive to play the litigation lottery and avoid settling cases that could otherwise settle. Potential recovery of non-economic damages would be permissible for an animal where they are prohibited from any close personal relationships. Claims for non-economic damages over injury to a sibling or grandparent are not compensable, but a family of 5 could possibly have individual claims over the loss of a goldfish under the bill. Does this mean that Maryland doesn't value siblings or grandparents? Of course not. Do we need non-economic damages to demonstrate the value to us of our pets? Of course not. There are good reasons Maryland has drawn lines to tightly restrict the categories where awards of emotion-based damages are available, and we would ask that you not expand them into pet litigation.
Good afternoon. My name is Phil Goldberg, and I'm testifying on behalf of the Animal Health Institute against 815. I've worked extensively on animal law issues, filing an amicus brief in the Court of Appeals in the Reeves case for the animal welfare community. AHI is a national trade association whose members work to ensure a safe and effective supply of medicines that keep pets healthy and help them live longer lives. We deeply cherish our pets and appreciate the hardship of losing a companion animal, regardless of the circumstances. AHI opposes this bill because allowing emotion-based damages for injuries to pets, as you've heard, is not the pro-pet position. Put simply, pets do not reap benefits when owners are awarded emotion-based liability for their injuries. Only owners benefit. but pets will suffer when owners can no longer afford important care products and services, from veterinary care to food, walkers, kenneling, and medicine, because of the increased liability costs these damages will impose on pet welfare providers. The issue of whether to allow emotion-based liability in pet cases has come up in 35 states over the past 30 years. No state in the country allows the type of non-economic damages sought in this legislation, under common law or statute. They have all found there is no legal or public policy basis for allowing emotion-based liability in pet litigation. This bill simply has no foundation in the law anywhere. Why? The main reason is that our emotional attachments to people and our cherished possessions are not compensable in litigation. Pets are no different from human best friends, many close relatives, and other things we highly value in our lives. The Court of Appeals in Reeves expressed concern that a pet owner could recover non-economic damages for the death of a pet, while the same person could not receive such damage for the loss of a best friend, sibling, fiance, or grandparent. Second, pet care products and services should not resemble human health care, where the threat of litigation and emotion-based liability award increased costs and dictate care. Third, this liability will be everywhere. 70% of Americans have companion animals, and they sometimes are injured or killed in many ways, from neighborhood scuffles to car accidents. Maryland already is ahead of most states in allowing the recovery of the costs of the treatment of the animal from the incident, and that makes sense and advances pet welfare. But awarding the owner emotional-based liability does not. In the interest of pet welfare, we urge you to oppose this bill. Thank you.
Questions? All right, Senator Cassidy has a question for the panel.
I guess for the last witness there. So I hadn't thought of how, so you raised the possibility, this sort of transforms veterinarian practice into sort of a, I guess, a scrubbed down a bit, but a version of the medical establishment where if the doctor is going to be liable for more than the value of the pet potentially, then every little kitty cat becomes potentially at least worth $10,000 in non-economic damages, right? I mean, if the cat itself may only be worth $5 or even no value at all, it'd still have a $10,000 value, because how could you, I mean, emotional pain is real, and so every little kitty cat case would be a $10,000 case, right? You would have to insure everything you do at a minimum of $10,000, right?
And I want to make sure we're clear, the value we place in our animals versus the litigation value and damages in a court, you know, in terms of trying to monetize that, are two different things. But you're right in terms of what the monetary value of that animal would be. It would automatically be $10,000 in every case. But more than that, and Dr. McClure talked about this earlier, and going back to the conversation you were having with the previous panel, the line between negligence and gross negligence is unclear. Nobody knows what it is. So every case would get filed as negligence and gross negligence, and it goes to a jury. There's no ability to settle or deal with that case in any rational way, because if they can convince a jury there's gross negligence, that gets them as high as they want. And so this bill would drive the exception would be the exception that swallows the rule, so to speak. But this bill would drive a huge hole through any existing law, again, in any state as to how these cases are working.
I mean, certainly you'd have to, I mean, if there was a case where you were in that realm between gross negligence and negligence, and you're up for settlement, and you could potentially have a dead bird case, and you're looking at settlement demands of $50,000 and the like for a dead bird case, potentially, right?
That's right. I mean, there was a case I recall up in Boston where the couple refused a $100,000 settlement because they said, we want enough to send our kids to college off of this. I mean, that's what we're looking at. I mean, it would not have a rational relation to the loss and the damages, because we all love our pets incredibly much. I love my dog. I know, and I grew up loving a dog. I love the dog I have now. I can't tell you I would put a price on that.
Okay. Thank you very much. It's interesting.
Could I add one comment? I don't mean to be, just to, on his, add to what he said. You said would every case be worth $10,000?
It's actually more than that, what he just explained. It's not just $10,000. It's only $10,000 if it's not gross negligence, but once you hit the gross negligence, was his point, there is no gap anymore.
Yes,
Right.
and even if it's just negligence, I mean, how do you decide who owns a pet? There's no title, there's no registration for most of them. So if somebody decides that all 5 family members are the owners, then is that a $10,000 claim or a $50,000 claim? And that was one of my points, is that it's not even necessarily clear that it would just be that.
Right. Thank you.
Thank you all very much. We'll help you for the final ways. Mr. Weintraub, come on up. Welcome.
Good afternoon, Mr. Chairman, members of the committee. Jason Weintraub here on behalf of the American Property Casualty Insurance Association, requesting an unfavorable report on Senate Bill 815. I think the prior panel hit pretty much every single point that I wanted to make as to why this bill should get an unfavorable report. So I will just say a me too and give you back a minute and 45 seconds. Thank you.
All right, seeing no further questions. Thank you very much. All right, with that, that'll conclude the hearing for Senate Bill 815. We'll now move on to Senator Lee with Senate Bill 816.
Yeah, thank you, Mr. Chairman. Can I have my panel come up? Okay, thank you. As always. Thank you. Okay. What happened to the chair? Is the chairman coming back? Okay. Should we wait? Okay. Senator Heddleman, can you take the chair? Okay. Thank you, colleagues. This bill is Senate Bill 816. The bill just provides guidance and protection for tenants and pets during the eviction process. It requires the Department of Agriculture to create a fact sheet that provides information to landlords and tenants about ensuring pet safety at the time of eviction. And during this time of record evictions, during this pandemic, faced by tenants largely exasperated by, of course, this deadly virus and also the economy, this is a very timely and important bill. There are 4 provisions to this bill. First is the creation of the Department of Agriculture's of the sheet as discussed, which will include basic pet care instructions for pets losing their home and contact information for shelters. Secondly, upon eviction, this bill requires that landlords to inspect the premises for pets and attempt some reunification. If unification is not possible, then the landlord is required to arrange for the pet to get to a local shelter. The third measure is that the shelter must be provided with the tenant's information to establish contact and attempt reunification and vice versa. The tenant will receive shelter contact information. Finally, the bill prohibits the pet from being just left on the curb along with other personal property. The fiscal note on this bill is very minimal, and we've been in communication with the Maryland Multifamily Housing Association regarding an amendment that places a link or code on the last document tenants received prior to eviction instead of a separate sheet. The bill protects landlords and tenants as well as the pets involved in an eviction. The eviction process is fraught with tension, as you know, and I suggest that this bill would provide information which would prevent loss or abandonment of a pet, as well as gives guidance to landlords. For these reasons, we respectfully ask for a favorable report on SB 816. We're open to discuss friendly amendments to make the process easier on all parties involved. However, providing additional information in summons is not a reason to block it. Our pets are very important than the trivial procedural issue, and I hope we will have this bill move forward. And I'll turn it over to my panelists right now. Just introduce yourself and your organization.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the State Director for the Humane Society of the United States here in Maryland.
We're here in strong support of Senate Bill 816, and thanks to the sponsor for her sponsorship of this bill. Animal and human welfare cannot be viewed independently. And so to help pets, and we must help people, and to help people, we need to also be looking to help their pets, and this bill does both. The sponsor's gone through what the bill does, so I will not repeat her words, but I do want to stress, these provisions are not onerous. They can be implemented through existing procedures and practices, so nothing in here is a significant new step or hurdle that is going to be placed in the way. Every provision in this bill comes from horror stories that we have heard either from the shelter partners that we work with or from housing advocates who reached out to us about some of the situations that their clients have encountered. It truly shows that common sense is not so common. We cannot simply allow pets to be left on the curb or doors to be open and pets to be let free in these situations that are already so fraught and difficult for all parties. We do appreciate MMHA for trying to work with us and the sponsors. We're open to continuing that conversation. We are not wedded to the exact place in the process where an individual receives this documentation, but we do feel paper documentation is important. All of us have been known to delete emails willy-nilly or to not be able to access a link in a timely manner. Having the paper document there does make a difference. We are supportive of the Maryland Legal Aid's amendments to broaden the definition of pet, and we're very open to what other types of technical evictions should be included in this legislation. For someone facing the trauma of losing their home, the added trauma of potentially losing their pet and being irrevocably sundered and separated from that animal is unimaginable. We hope that this committee will move this legislation to help both our tenants facing eviction and their four-legged companions. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Emily Hovermail on behalf of the Humane Rescue Alliance and our thousands of supporters in Maryland, here in enthusiastic support of Senate Bill 816, legislation that helps protect pets and their owners by putting in place very basic guardrails for pet owners when evictions happen. The Humane Rescue Alliance honors more than 150 years of commitment to protecting animals, supporting families, and advocating for positive change to create a world where all animals can thrive. We are the largest animal services provider in our region, adopting out over 4,000 animals to Maryland families last year. Pet ownership has increased to an estimated 70% of U.S. households that own a pet, and studies consistently show that the vast majority of people consider pets to be an important member of the family. The tremendous surge in pet adoption and fostering during the pandemic has underscored the value and importance of the human-animal bond. Now more than ever, with so many of us experiencing unparalleled isolation, the importance of animal companions cannot be overstressed. And peer-reviewed studies show that the bond between people and their pets is linked to several health benefits, including decreased feelings of loneliness, anxiety, and symptoms of PTSD. As has been said, for someone who is in crisis losing their housing, the added trauma of being separated from their pets is simply unfair and untenable. The senator has aptly described all of the protections in the legislation, and I will say, through our direct experience as an animal sheltering organization, backed up by those of housing advocates, we see situations every day where eviction results in the separation of pets from their families. These practices are the most basic of protections for pets and their owners. We should do everything we can to keep pets out of animal shelters and with the people who love them. Thank you.
Hello, Mr. Chairman and members of the House Environmental... Okay, sorry. Hello, Mr. Chairman and members of the House Environmental and Transportation Committee. My name is Catherine Dangle, and I'm a 6th grader at Glenwood Middle School in Western Howard County. I'm here to support Senate Bill 816, which creates protections for pet owners facing evictions. I moved in 2019, and I remember how difficult it felt, how unpredictable. I can only imagine if my family was facing an eviction, especially if we didn't know if our pets were okay. I moved under optimal circumstances. It was planned, I really wanted to do it, but it still felt out of control. We knew that everything would be okay when we moved. Most people facing evictions don't. When I was moving, I really needed my dogs. They always made me feel better. if I didn't think they would be okay, it would be so much harder. I want to make sure that everyone can have their pets through these difficult times. When I was moving, there's a lot of planning, even for an optimal move. If we didn't have help planning the move, I doubt that everything would have gone so smoothly. I want more people to have these resources and have better moves. And if the pets don't plan for it, I'm so sorry. If the people don't plan for it, why should the pets suffer? Our pets do so much for us and are so loyal. I was lucky on my move because my pets got to stay with me. I want everyone to have the same merits. Please vote yes on Senate Bill 816.
Chairman Smith, members of the committee, my name is Caroline Griffin. I'm a Baltimore City resident in Senator Carter's district. I am the former chair of the Baltimore Animal Abuse Commission and am a co-founder of Show Your Soft Side. I support Senate Bill 816. This bill simply codifies best practices, and even though there is tremendous coordination in Baltimore City between our sheriff's office and animal control, we still need this bill because cases fall through the cracks. On January 7th, a citizen had contacted my nonprofit. Her mother-in-law had been evicted the day before, and the deputy sheriff did not allow her to remove the 3 cats in the apartment. Subsequent calls to the landlord were unanswered, and so she called us asking for guidance on how to get her mother-in-law's cats out. We directed her to call animal control, and the animal control arrived the next day. And these cats were lucky. Unfortunately, some animals are not so fortunate. And animals left for extended periods of time endure suffering in the extreme. Baltimore Raven Ronnie Stanley is one of the spokespeople in my nonprofit. He also started a foundation to help dogs. And 6 years ago, he adopted a dog from Barks that had been locked in a house without food and water for several days. The dog actually chewed a hole in the wall in a desperate attempt to get out. And this is just very typical of what happens. My written testimony references some expert testimony from a forensic veterinarian that describes this phenomenon, but I think we can all understand what is happening without expert testimony. I understand that this places a notice burden on landlords, but I would argue that the benefits far outweigh the burdens on our landlords. It would also save taxpayer dollars because our municipal shelters are the ones who are paying the cost of care for these animals. I urge you to issue a favorable report. Thank you.
Good afternoon, Chair Smith, members of the committee. My name is Lisa Radoff, for the record, and I'm a resident of Senator Heddleman's district. Thank you for the opportunity to testify in person before you today. I'm here in support of SB 816 for all of the compelling reasons that you have heard from the sponsor and all of the advocates. So I will be brief. These are very easy measures for landlords to implement. They're used to doing these kinds of notices for lead paint in buildings before 1978, et cetera. The good that is done by this bill does far outweigh any kind of burden that there would be on landlords. In short, I hope that you guys will support this very compassionate bill. Thank you so much to Senator Lee for sponsoring it.
So, thank you very much. All right, questions from the committee? All right, with that, thank you very much. Thank you for the panel. Excellent testimony all around, especially from Catherine, who's been here all day. I saw her up in the gallery and is now in JPR, so welcome. Future senator for sure. All right.
I'm from the Legal Aid Bureau. I was supposed to testify on.
Yes, I'm going to call the next panel.
Okay,
Yep,
I'm sorry.
well, come on up. If you're up here, I assume Ms. Bernstein, Mr. Washington's not here, and then Mr. Wiggins.
Okay, I'm sorry. I
No
didn't
worries.
hear.
No problem.
Okay, good afternoon, Chairman Smith and members of the committee. My name is Donna Bernstein. I'm a staff attorney with the Legal Aid Bureau. I work in Baltimore City, and my specialty is I work in the Housing Consumer Law Unit. Maryland Legal Aid supports this bill for the obvious reasons, and I would venture to say that most of the problems that, when this comes up most often, is in the community that I serve. So we support it for the obvious reasons, which are that it creates a safety net for the animal. It also increases the likelihood of reunification, and also because when you reunify and take an animal out of a shelter, then that creates more room for another animal and then reduces the likelihood of euthanasia for lack of space. But I want to point out something else, which has kind of been a project of mine for many, many, many years. I make it a point of asking my clients about their animals and creating resources for them. This bill helps to create actually an avenue for low-income people to get a great deal of information. I have worked with Johns Hopkins School of Public Health on this. We have worked to see what ways we can come up with that allow people to access, well, how would their pets allow them to access additional information? Almost every shelter that I have worked with has information in it. When the person who's trying to reunify with their pet or vice versa and the shelter calls them, they then open up an avenue for a great deal of information, including legal assistance, not only with their housing, but with benefits, with everything. So this bill creates a huge avenue to assist low-income individuals. We would ask that you expand the definition of pet because there are far more animals left behind, like rabbits and such, and that the landlord be required to follow the same rules in situations where there's just an end of a lease or a failure to, that they don't want to renew the lease. Thank you very much.
Good afternoon, Mr. Chairman, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. We appreciate the intent of this bill, and we thank the sponsor for meeting with us. We are open to continued discussions. The good news is that this seems to be rare. We went back through property visit logs from the Baltimore City Sheriff's Office over the past 3 months, and we're only able to identify 2 instances of an animal being present at an eviction, and that was just present. You know, unfortunately, we do see from time to time animals abandoned during the eviction process. It's very sad. Obviously, we don't want to see that, but we have some practical concerns with the bill, namely, we think the information is better served in the warrant of restitution, which is developed by the court. You could put a link in there in the notice that goes to the tenant. There are a significant number of notices that a tenant receives in a place like Baltimore City already, and we would hate for this information to accidentally obscure another document that has information like the court date or how to avoid the eviction. And so, again, open to continued conversations and appreciate the intent. Happy to take any questions.
All right, seeing no questions, that'll conclude the testimony for Senate Bill 816 and the hearing for Senate Bill 816. We'll now move on to Senator Carter with Senate Bill 775.
Good afternoon, Chairman Smith and members of the committee that are here. Thank you so much. So this should be an easy bill, and I thought about this. This is a bill that we should pass, not because it would ingratiate us with every single voter and driver in Maryland, but because it's the right thing to do for the people. It just involves an increase of the daily payment for jury service. So currently, the first 5 days of jury service, there's a payment of $15. This would simply raise it to $30. Currently, employers are not required to compensate employees for jury duty, which means that individuals who earn a daily wage are at a greater risk of losing much-needed income by serving. Unfortunately, many wage earners are not in a financial position to lose an entire day's wage, let alone 5 or more. For example, a full-time employee that is paid the state's minimum wage, which is $12.50 per hour, loses $85 per day for every day served on a jury. Over a 5-day period, that adds up to a loss of $425, which is a significant amount of money for anyone. Currently, our closest neighbors, Virginia and the District of Columbia, pay their jurors more than Maryland. Virginia pays $30 a day, while the District of Columbia pays many of its jurors $40 per day. This bill simply places Maryland on par with our neighbors in the region. Some may believe that increasing what jurors are paid is unnecessary, particularly since serving on a jury is a civic duty and jurors earn $50 per day after 5 days of service. However, this thinking is harmful to the purpose of our jury system, particularly the role that jurors play, which is to listen to the evidence during a trial and decide what facts the evidence has established, draw inferences from those facts to form the basis of their decision. I think it goes without saying that a person sitting there worried about the adverse financial effects of sitting on a jury is less likely to focus on carrying out their duties than a person who is unburdened financially. This is not to seek to completely unburden them, but to lighten that burden. The result is a less effective jury service than reliable outcomes for plaintiffs and defendants. However, higher pay would lead to fewer jurors seeking excuses from service and aid in the impaneling of more representative juries. While it is understood that juror compensation was never meant to serve as a substitute for a salary, raising the daily rate of a juror compensation to $30 per day would provide some small relief for the sacrifices made by jurors. Overall, Senate Bill 775 aims to alleviate financial burdens placed on individuals by modestly increasing the compensation they receive. This bill has received a favorable endorsement from persons across the state, including the Prince George's County Court Watch, the Baltimore City Court Watch, Common Cause Maryland, the League of Women Voters, and the Maryland Justice Project. For all of those reasons, I would urge a favorable report. Thank you.
Excellent. Thank you very much, Senator Carter. Questions from the committee? Seeing none, thank you very much. And I think Morgan Drayton is not here, so. Oh, there you are. There. Come on up. Welcome.
Thank you. Thank you, Senator Carter, Chairman, and members of the committee. My name is Morgan Drayton, Policy and Engagement Manager for Common Cause Maryland, and I'm so grateful to have the opportunity to offer testimony in support of SB 775. I won't rehash the bill since Senator Carter did such a great job explaining it, but low juror pay, as we know, is a significant financial burden that prevents many low-income people from serving on a jury. Most people cannot afford to miss one or several days of work as they need to support themselves and their families. And the current established rate of $15 per day barely covers transportation and meal expenses for the day, let alone the opportunity cost of a lost day's wages. And because income inequality is strongly correlated with race, juries have become less racially diverse and tend to be composed of only those who can afford to serve unpaid or who have employers that will pay them while they are serving. Jury diversity advocates have called for higher pay for jurors for almost 3 decades, and research shows that juries lacking in racial diversity exacerbate the harm that the criminal legal system inflicts on people and communities of color. One suggested amendment that we at Common Cause would like to put forth is that while an increase of $30 or to $30 would definitely be an improvement, we are concerned that SB 775 falls short in covering the lost wages for the day, and we understand that a higher per diem rate may not be possible at this point, and we instead recommend requiring that the General Assembly return to review jury compensation every 5 years to ensure that it is in line with inflation and market needs. And as higher compensation for jury duty will ensure that jury pools are more reflective of the communities that they're serving, we respectfully request a favorable report and hope that you will take our amendment into consideration. Thank you.
All right, excellent. Thank you very much.
Thank you.
Seeing no questions from the committee, with that, that'll conclude the hearing for Senate Bill 775. We'll now move on to Senator Eckert with Senate Bill 853. Welcome.
Thank you very much, Chairman Smith, Vice Chair, and members of the Judiciary Committee. I'm here today on a very interesting bill. It's kind of a different twist on an old theme, and it has to do with retaining wealth within families through the generations. So thank you very much, Senator Addie Eckert, for the record here on testimony for Senate Bill 853, the Maryland Real Property Transfer on Death, TOD Act. Many low-income Marylanders and families face significant barriers when trying to transfer property to the next generation, including liens, in cases where there is no will during sudden and unexpected deaths. These challenges that come from a lack of will create unreasonable economic burdens for family and can at many times displace them, leading to increased rates of homelessness. This has been especially seen in situations in our rural areas where multiple generations live and work on farm property. During the pandemic, we've also seen an increase of unexpected deaths across the state, many of whom have been heads of households who had not yet drafted a will. Senate Bill 853 would allow a real property to transfer to a beneficiary automatically upon death, creating a transfer of death deed. This act would not apply to real property owned by a corporation, business, government body, or any other legal or commercial entity, and would be creating an alternative process in the case where there is no will. This product before you today came from the result of a piece of legislation that I cross-filed with Delegate Hill last year. And when she went before the committee in the House, they said, just go back and do your work group. We're not passing a work group. Just get it done and bring back in what you want. So we actually looked and spent the interim working on this process, and you can see attached to my testimony should be a list of individuals who participated with us. And Meredith Lathberry, who is here to testify as well, also helped in this process because she was bringing me these situations from the local area, saying we need to do something about that. So this is the product. It's a work in progress. As you know, you have a packet not only of the bill, but you have another packet about the same size that are the amendments that came when we worked with the Division of Law who look at estates and trusts. So these amendments merely rearrange this. I don't think there were any substantive changes. In addition to that, I've been in conversation with SDAT. We forgot SDAT at the table, so I've apologized to Jonathan. We talked about that, and we hope that we will be coming in with amendments that actually will go ahead and, if we can get your authorization to pass the bill, but then allow a period of time that we could set up the implementation, because, you know, if you're going to create a registry, we have to have it scanned and where we're going to put the documents and all those mechanical aspects of it. So if you want, I can walk you through the bill. It provides definitions. It says what it doesn't apply to. It says what it does apply to. It says under what circumstances. And we wanted to make it easy for people to use. So you will see in here a lot of language about questions and answers about the process that need to be included, so there is no doubt of what this is and what this is not. So I just would urge your favorable consideration, and if we can get this passed, it will provide an alternative to not having a will that can be available so that folks will not be displaced and wind up homeless. Thank you very much, Mr. Chairman and committee members.
So thank you very much, Senator. And we'll turn to the committee for questions. See, Senator West has a question.
Thank you, Mr. Chair. Interesting bill. I'm wondering whether or not you had the time to share this bill with the Executive Council of the Maryland State Bar Association's Real Estate Section and the Executive Council of the State Bar Association's Estates and Trust Section.
Yes, Meredith, if I could bring up another witness,
Oh,
is that
absolutely.
right?
Sure.
I have two witnesses, excuse me. Would you like to hear from them or just answer the question?
Well, I can hear from them. That's,
All right.
Yeah, let's proceed with the testimony, and then we can do questions. We've got more than one question. So if Ms. Hennon, you can go first, or whoever, go first, and then we'll take questions from the entire panel.
Go ahead. Thank you.
Thank you, Mr. Chair, and members of the committee for the opportunity to be here today. My name is Amy Hennon. I am the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyer Service. My organization connects low-income folks with volunteer attorneys in their communities. In addition, we have a number of staff-supported projects that both support our volunteers and also deepen the impact of our work. Two of those projects are our Advanced Planning Project and our My Home, My Deed, My Legacy project. Our Advanced Planning Project does a lot of outreach to folks about the importance of estate planning, not just for low-income folks, but for everybody. And then our My Home, My Deed, My Legacy project is about connecting, helping individuals that are living in an heir property that need to get their name on the title to their home, help them resolve those issues, help them through the probate process. So Maryland already has a life estate deed, but this is, in fact, the transfer on death deed, it has some important distinctions that are going to be very helpful, especially for low-income folks. Our clients see many, many difficulties when they're trying to get through the probate process, and the statutory form that is created through this process actually makes the process much easier. This is very similar to the statutory form that the legislature has created for healthcare powers of attorney, financial powers of attorney. My written testimony contains the story of our client Thomas and his struggles to get his name on the deed and how a transfer on death deed could have helped him. But I also want to share the story of my client Loretta, who lives in St. Mary's County. Her property was in her husband's name alone. When he passed in 2019, she struggled she had a very difficult struggle to keep up with the property taxes, and this was before House Bill 610 passed last year that would have allowed her to get the homeowner's property tax credit. The consequence was that she nearly lost her home, and if her husband had been able to set up a transfer on death deed, this would have very much allowed her to be able to stay in the home and not have the difficulties that she experienced at the time. And consequently, we would urge a favorable report. But in answer to your question, Senator, I will say that I know that the group working on this actually stemmed from a couple of years ago from the COVID-19 Access to Justice Task Force from the Attorney General, and then recently they had been working with both the Estates and Trust section and the Real Property section, and that's one of the reasons why I believe that there is going to be a shift from the Estates and Trust section to the Real Property section at the request of both of those groups.
Good afternoon, Chair and members of the committee. My name is Meredith Gerard. I'm the Executive Director of Midshore Pro Bono. We provide free and low-cost legal services to folks in our community who could otherwise not afford an attorney. We assist about 500 clients annually with elder law issues, and so many folks really struggle with accessing the legal system. Many cannot afford an attorney to go through the probate process. Many cannot afford an attorney to be able to develop the documents that they might need. A recent example, we were working with a senior gentleman who is also blind. He wanted to just transfer the deed to his property to his adult son who lives with him and is his caregiver. And so while we were able to have a pro bono volunteer help him with that, it probably costs between $750 to $1,000 for those legal services. We're still struggling to complete the recordation of the deed. And those are the kinds of barriers that make it very difficult for folks to be able to have that intergeneration transfer of wealth and property. So when people have access to low-cost tools, it makes it so much easier for them if they don't have to go find an attorney to assist them. And we do this in other situations. If you are establishing the beneficiary for an insurance policy, you fill out some paperwork. If you want to transfer the title to your vehicle after death, there is a form that you can fill out. So similarly, while property is a very important asset, Having the ability to do this outside of probate and having the ability very narrowly to do this without an attorney would help our clients tremendously. And so for these reasons, we recommend your favorable report. I want to applaud Senator Eckhart and the other folks on the work group who really came together to make this happen, and we encourage your support. Thank you.
Thank you, Mr. Chair. I just want to express the view that I would feel much more comfortable dealing with this quite complicated and lengthy 25-page bill if I had the assurance that the executive councils of those two sections of the State Bar Association had reviewed it and either supported it with amendments or, opposed it. So coming today without any indication as to whether the significant elements of the State Bar Association that deal with these issues have any view on this bill at all, it makes it hard for me to grapple with it. So could I suggest you take it to those organizations and see if we can get a letter from them indicating that they have reviewed it and they think it's fine, or they think it's fine with some amendments or whatever. That would make it, I think it would be easier for me. Certainly, my guess is other members of the committee would also appreciate that information.
Thank you, Mr. Chair. So if this bill is implemented, will creditors be taken care of before the transference of the property? Does that not make sense?
It does make sense. And I want to think it through so that I can answer your question properly.
Okay.
If there is, for instance, a judgment on the if there is a judgment that exists out there, if the creditor has sought a judgment, there is a process to get a lien on real property. And so as long as they have taken that step, then indeed there would need to be some sort of payment to the creditor in order to get the deed into the person's name.
The way I read the bill, it seems like this transference would be pretty rapid, right?
It makes it easier so that they don't have to go through the probate process, but as long as the creditor had gotten a judgment, and in fact had gotten a lien as part of that process.
A lien on the property?
Yes. If a judgment is entered in the state of Maryland in every county other than Baltimore City, the creditor has to file to request a lien on any real property. As long as they've done that, as long as they've perfected their lien, they have a judgment that has to be resolved in order for a transfer to occur.
Okay.
In Baltimore City, that lien is automatic.
And just to piggyback on Senator West's question, I'm getting a little more comfortable with the roles and responsibilities of our Register of Wills and our Orphans Court judges. And I'm trying to see how this interacts with those folks. Have they been reached out to see if it would disrupt their processes, cause any alterations in the way they do business?
My understanding is that that the Register of Wills has been a part of this process throughout, and is not opposed to this.
When you say Register Wills, you're talking about all the Register Wills?
All of the registers.
Of all counties?
Yes.
And they do not?
They're not opposed to this.
Okay, thank you.
8:53, thank you very much, Senator Eckert.
Thank you very much.
All right. Senator Heddleman, do you want to take for 1 second? All right, we'll now move on to my bill, Senate Bill 897, and then we'll go to Senator Huff, because I don't think you have witnesses, do you? All right, I'll be quick, too. All right, good afternoon. Senator Smith here to testify on behalf of Senate Bill 897. Now, for this bill, I'd actually to pull out your bill file and follow along through the actual bill as I go through it. But essentially, this bill is actually part of a package. It was part of a bill that was attached to one of Senator Carter's bills that was eventually just withdrawn in 2021. But it deals with not being able to be incarcerated for your failure to pay court fines and fees. And it's based on the premise that, I'll just quote from the Bearden versus Georgia case, that the Constitution prohibits a state from imposing a fine as a sentence and then automatically converting it to a jail term solely because the defendant is indigent and cannot forthwith pay the fine in full. And then second, the American Bar Association Guideline 3 on courts and fines and fees, the National Center for Access to Justice, and the Brennan Center have all talked about, they have all recommended that curtailing incarceration for court-imposed fees. Now, the way that the bill is drafted, there's a constitutional requirements that require essentially this investigation to happen before the court suggests incarceration for failure to pay the fines or the fees. And so the way that the bill is drafted, if you follow me on page 1 of the bill, line 20, we change that from a may to a shall. And that's front-loading it. So you have to conduct that investigation before you make this assessment. You have to have that investigation before you make, of all the cases that are fines and fees, instead of the way that the current statute is addressed, which just says, after an investigation, then you can decide whether to incarcerate someone. So what we've done in the bill is front-loaded it. That has engendered the opposition from the judiciary, because it's not only the separation of powers issue that they've addressed, but also that it essentially makes it that you'd have to go through this investigation for all the cases that have fines. And so that would, expand the scope of what they're doing such that it would cost them a lot of money, and it would just be impracticable. So what I'm suggesting, and what the offensive part of the statute to me and to all of you should be, is if you look on page 2, if you just look at from line 16 on, subject to the limitations in the subsection, the court shall determine the period of imprisonment for default in payment and fine, and then it goes down. And you can see that the period of imprisonment may not exceed $1 for each, 1 day for each $10 of the fine, and so on and so forth. That shouldn't be in the code under any circumstances, even after someone has conducted the investigation. So what I'm suggesting, and I think that these amendments will, assuage the concerns of the judiciary, is that you take away that front load process, so you're not investigating every single fine and fee. You just put that back to a may on page 1, and you convert it on the top of page 2. You say that after an investigation, you take out those brackets that the court considers necessary, so you're keeping the current statute as is, and then you say that the court may convert the fine to community service, or may reduce the fine to an amount that the court determines the defendant is able to pay, and then you just strike the rest of the bill. I think that would address the court's concern, the judiciary's concerns with separation of powers and cost, while eliminating the prospect of incarceration for failure to pay a fine or a fee. You know that you're incarcerated, you're not able to work it off, you're not able to pay, you're costing the state money, whereas if you're doing community service, you're adding a benefit to your community. I think it's a win-win, and it stays away from the separation of powers issues, and it stays away from the cost issue. And so with those amendments, I'd ask this committee for a favorable report, and we'll stand for questions. Senator Heddleman, if you'd like to tag one of the senators for question. I think Senator Castley or Senator West had a question.
Senator Castley.
Would you, thank you, would you leave in the installment plan option? You were taking stuff in and out. The page 2 of your bill, you have halfway down, it says authorize a installment.
So it says the court may reduce the fine to an amount that the court determines the defendant is able to pay, and it'll hard stop there. Strike the rest.
You wouldn't have the installment plan piece?
No.
Why?
I mean, it should, I guess you could keep that. It may reduce the fine to the amount the court determines is able to pay. I mean, that should fall within it. It's more clear and expressed, that's fine.
I'm not sure the court would want the clerk to authorize that. The judge would probably make that decision himself.
That's in their opposition.
It seems to me that, I don't know that right now, maybe Senator Carter knows, but I haven't been in a case where they were allowed installments. It was pretty much pay today as soon as you walk out. And sometimes that's a bit of a nut to crack.
Yeah.
And for a court, I don't know if they have that option right now or not to say, can I pay this in 4 equal installments over the next year? I don't know if that,
Yes, I haven't seen a specific installment
get it done.
The point is just to, I mean, it's offensive that it's on the statute that you can be incarcerated for not paying a court fee. It's fine. So, Senator West.
Thank you, Madam Chair. So your proposed amendment takes out the word contumacious?
Contumacious, yeah, that'll be taken out because
That's a
it's
shame.
struck.
I've never
In
seen
fact,
that, I've never seen that word in the
Well,
Maryland
contumacious actually is
statutes.
still on the first part of the statute. So it means kind of a flippant response or
No, it was a sort of a flippant question. I
It means
just love the word.
It's stubborn. yes,
Stubbornly or
stubborn.
willfully disobedient to authority.
That's right. So it's not contemptuous, but contumacious.
Yeah, no, I loved
But I think
contumacious.
if you are contumacious, you are probably contemptuous.
But in a more serious vein, if someone has stolen money from an elderly lady by using fraud and is gotten $25,000 from her, it would seem to me that just community service would not be sufficient. And so I like the idea of keeping the installment plan in there so that the person who did that would have to, over the years, if necessary, pay back the money.
So it's not the underlying offense, it's the actual court-imposed fine or fee for the offense. So it's not, just to be clear, so I get what you're saying, but the installment plan, to Senator Cassidy's point, I think may make sense. So we'll look into that because it's the court, we're leaving it the court's discretion, but the installment plan is probably in that, but I think it's inoffensive to keep it.
Thank you.
Yes.
I have an alternative answer for you.
Sure.
Senator West, in response to your question, this bill does not actually address restitution, which is most commonly what you would see with a situation like that. This is simply addressing the court fines and fees.
It's just a fine.
Yes.
So not the underlying offense, it's the court fine and fee. Yeah, sorry, yeah.
Are there any other questions?
All right. There we go. All right, with that, thank you all very much.
Distinguished senators, thank you for the opportunity to be here. Again, I'm Amy Hennon with the Maryland Volunteer Lawyer Service. Earlier, I spoke about a couple of projects that my office has today. Right now, I'm going to speak about a different one, which is our workforce development project. We're providing wraparound legal services to low-income folks that are often returning citizens or have been kept out of the traditional economy in a variety of ways and are looking to re-enter that, become productive members of society. We're providing those wraparound legal services to help them remove a variety of barriers. Often we do a lot of expungement. We help them get their licenses back. And then we help them, in many cases, we help them resolve fines and fees that are an impediment to them being able to do a number of things in society. I think it makes plenty of sense why we certainly wouldn't want to jail these people. But in addition, I just want to share that the composite client for somebody who comes through our program is generally somebody who is normally a young person, but has gotten some sort of work. They need a license in order to be able to commute to that job, this better paying job that is going to provide for them, and usually the child or parent that they're caring for is not available to them by public transportation, and so they need to be able to have their license in order to do this, and then the fines and fees are often an impediment to being able to get that license. And so the ability to have an ability to pay rubric done for them to determine if they have the ability, and then giving them something affordable that they can pay is in fact a huge benefit to them and their ability to be a good and productive member of society. And with that, I would thank you for the opportunity to be here.
All right, excellent, thank you very much. All right, and with that, that'll conclude, if there are no further questions, that'll conclude, oh, sorry, Caleb, you're up.
Thank you, Mr. Chairman, members of the committee. My name is Caleb Josso. I am a policy advocate with the Job Opportunities Task Force, an independent nonprofit organization that develops and advocates policies and programs to increase the skills, job opportunities, and incomes of low-skill, low-wage workers and job seekers in Maryland. We're here today in support of Senate Bill 897 for many of the reasons that have already been stated, especially the reasons being that there are certain individuals who do encounter the justice system who may need alternative ways of paying off the fines and fees that are associated with the process while they are in the system trials. So in 2018, JOTF released a report called The Criminalization of Poverty, which dissects the pathways in which Maryland residents from impoverished communities encounter the criminal justice system. Part 2 of the report goes forward to outline how extensive fines and fees related to interactions with the criminal justice system in communities of color. These fees for service sometimes include, but are not limited to, court-related fees, home detention, parole, and probation, public defender, representation, etc. We are in favor of this bill because it establishes a way for people to comfortably go forward in their process of answering for things that they may have done, being a part in this system, as well as taking on those fines and fees in a way that does not put the immediate financial burden on them, so that it gives them a way that they can still have a productive role in society without the fear of further incarceration for lack of ability to pay. So we urge a favorable vote. Thank you for your time. If there are questions for JOTF, I'm happy to take them back to my supervisor and provide you your office an answer as soon as possible. Thank you.
Excellent. Seeing no further questions, thank you very much. And with that, that'll conclude the testimony in the hearing for Senate Bill 897. We'll now move on to the final bill of the day, which is Senator Huff with Senate Bill 746.
Yeah, thank you very much, Mr. Chairman. Senate Bill 746 is a local bill, increases the salary of the Frederick County Sheriff at the beginning of the next term. Currently, the Frederick County Sheriff makes $125,000 a year. We've not raised it since 2014. This would increase it with the amendments that are coming in to $140,000 the first 2 years, $150,000 the second 2 years. It was unanimous in delegation. Happy to take questions if there are any.
All right. Thank you, Senator Huff. Seeing no further questions, that'll end the hearing for Senate Bill 746. All right. So we are going to, let's take a 10-minute break, and then we'll roll out the list of things. It's kind of a working voting session. Most folks have been briefed on the package that we're going to be looking at. I know that there are some delegation letters that are still forthcoming, but this is going to be a work session / voting session. So we will work on the material that we have. I may bring out the whiteboard. It's going to be fun, and we'll go from there. All right. So just take a 10-minute break, and we'll vote. Hopefully we'll be out of here. And then if all goes well, we will not have to vote on Friday. Really? Unless you want to. I don't think it's going to go for, I really don't think we're going to be here longer than, well, it depends, right? Well, we might have some important bills to vote on Friday. We are, yeah. So, yes. So, 2 hours max. I mean, we'll see. We'll see how the discussion goes.